The government is expected to lay before Parliament a statutory instrument to change the date of the UK's exit from the EU in UK law to a date later than March 29th. Now, statutory instruments are the most common type of what is known as delegated legislation. They are used to add detail, update, and sometimes even amend Acts of Parliament without Parliament having to consider a new bill. Now, in order to lay a statutory instrument, a minister must be granted the power to do so within an Act of Parliament. This is sometimes referred to as a parent act. Now, about 1,000 SIs are laid before Parliament each session, and each one will usually be assigned to one of two types of scrutiny procedure, the negative procedure or the affirmative procedure. Now, the type of scrutiny procedure assigned to an SI will be set out in its parent act. The EU Exit Day statutory instrument is subject to the affirmative procedure as set out in Section 14 of Schedule 7 of the EU Withdrawal Act 2018. Now, in accordance with this procedure, the EU Exit SI will be laid in draft and can only become law once both the House of Commons and the House of Lords have debated and approved it. Now, normally this process takes around 6 to 8 weeks to complete. However, this particular SI will have to be debated and approved by both Houses of Parliament in a matter of days. Now, in the House of Commons, SIs subject to the affirmative procedure are usually debated in one-off delegated legislation committees, consisting of 17 MPs and with a senior MP in the chair. These committee debates can last no longer than 90 minutes and are held on a motion that this House has considered said instrument. Now, this means that the motion to approve it still has to be voted on by all MPs in the chamber without debate on a separate day. However, the government can choose to hold the debate on the SI in the House of Commons chamber instead of a delegated legislation committee. Now, in all likelihood, given the political importance of the issue, that is what will happen with the Exit Day statutory instrument. The standing orders of the House of Commons also say that debates in the chamber on SIs should last no longer than 90 minutes. However, the government can move a business motion to set aside this limit in order to provide time for debate. Now, if an affirmative SI is debated in the chamber, MPs will vote on a motion to approve it at the end of the debate. In the House of Lords, debates on SIs subject to the affirmative procedure can be held either in Grand Committee or in the chamber. Now, again, it is most likely that the EU Exit statutory instrument will be debated by peers on the floor. Unlike the Commons, there is no time limit for debate. Normally, debates on affirmative SIs cannot be scheduled until the Joint Committee on Statutory Instruments, the committee charged with considering the technical merits of all SIs, has reported on the SI. However, in exceptional circumstances, the committee could expedite consideration of the EU Exit SI to ensure that it can be debated and approved by the peers by March the 29th. Alternatively, peers could decide to set aside this rule if absolutely necessary. Crucially though, statutory instruments cannot be amended by Parliament. MPs and peers are therefore confronted with a take it or leave it proposition. Accept an SI even if they find it unacceptable, or reject it entirely even if they find some elements are acceptable. As a consequence, statutory instruments are rarely rejected. Since 1950, the Commons has rejected just 11 and the Lords has rejected 7.